Welcome to This Week in Education Law School Administrator's Guide, episode number 3. Each week, I share up-to-date court decisions on education law. I pay special attention to the decisions and arguments related to school administrators' daily work. Today, I focus on a case about a school board's policy about public participation. Here are 2 questions about the public participation policy. First, does a school board violate a community member's First Amendment rights when the school board terminates the board participants' personally directed antagonistic statements? Second, can a school board require an in-person pre-registration for speaking at board meetings? In the case I introduced this week, 4 community members attended school board meetings to criticize the school board's handling of gun-related issues. In March 2018, they attended the first school board meeting, where the board discussed arming teachers and the student protest. One of the community members tried to speak, but learned upon arrival that they needed to complete a public participation form in person at least 2 business days before the meeting. They pre-registered for the next school board meeting, in which the board passed the resolution of arming staff. 3 of the community members expressed their disdain for the resolution and the punishment of student protesters. Board president responded to their criticism, emphasizing the board's effort to create a safe learning environment for all students and their commitment to remaining neutral on political issues. The same community members spoke again at the following board meeting in May 2018. One of the community members' name was Billy. He turned to address the room and read from a prepared speech, accusing the school board of threatening the school to punish the student protesters. Billy was interrupted by the board president, who asked Billy not to use the word threatening. Billy then called the board's justification offered at the prior meeting for punishing a smokescreen intended to conceal their true motivation for punishing students, to suppress all opposition to pro-gun views and push its pro-gun agenda. Billy was interrupted again. This time, another board member asked Billy to stop putting words in the board's mouth and saying things that are not facts. The board president then asked Billy to stop and warned that if he continued, security would escort him out. Billy continued, finishing his speech while a security officer escorted him calmly from the room. In total, Billy spoke just under 3 minutes, which was the limit of speaking time according to the school board's public participation policy. About half a year later, in January 2019, Billy completed the public participation form and arrived at the board meeting with 3 other community members. The school board allowed only Billy to speak because the others failed to submit their own forms. They sued the school board, claiming that the school board violated their First Amendment rights. The district court found no First Amendment violation. The community members appealed to the U.S. Court of Appeals for the Sixth Circuit. What do you think? Do you think the school board violated the community members' First Amendment rights? The Sixth Circuit first answered the question, did the school board violate Billy's First Amendment rights when it prevented Billy from speaking at the May 2018 board meeting? The school board implemented its public participation policy, in which authorized the presiding officer to interrupt, warn, or terminate a participant's statement when the statement is too lengthy, personally directed, abusive, off-topic, antagonistic, obscene, or irrelevant. The presiding officer can request any individual to leave the meeting when that person does not observe the reasonable decorum. The presiding officer can also request the assistance of law enforcement officers in the removal of a disorderly person when that person's conduct interferes with the orderly progress of the meeting. The Sixth Circuit reasoned that it constitutes viewpoint discrimination if the board excluded speech merely because it criticizes school officials. The school board may not censor speech merely because it is offensive to some. The policy against attacks on people or institutions during the public comment portion of a city council meeting could be construed as viewpoint discrimination. The same applies in this case. The school board's restriction on antagonistic, abusive, and personally directed speech was in violation of the First Amendment if those speeches were prohibited merely because it opposed or offended the board or members of the public. According to the Merriam-Webster dictionary, the definition of antagonistic is showing dislike or opposition. The definition of abusive is harsh and insulting. So, antagonistic restriction, by definition, prohibits speech opposing the board. All of the three terms plainly fit in the broad scope of impermissible viewpoint discrimination, because they prohibit speech purely because it disparages or offends. The court noted the board president's testimony, in which the board president said, if the speech is perceived to be particularly offensive or abusive, then yes, I would stop the speaker. And then, when it came to a point where Billy was personally attacking and people were getting offended, I stopped him. Video evidence confirmed that another board member did take offense to Billy's comments, which prompted Billy's removal after the board president interrupted Billy initially for accusing the board of threatening school administration. The board president later clarified that he stopped Billy because he found Billy's speech hostile, personally directed, and abusive. And the board president later recalled the incident. Billy was being basically unruly, not following the rules, being hostile in his demeanor. He let Billy speak until other people were starting to object and getting offended by it. But the video evidence contradicted much of the board president's testimony. In the video, Billy spoke calmly, used measured tones, and refrained from personal attacks or vitriol, focusing instead on his stringent opposition to the board's policy and his belief that the board was not being honest about its motives. The Sixth Circuit noted that, having already found the abusive and personally directed restrictions facially unconstitutional, their application to Billy's comments also constitute impermissible viewpoint discrimination. Accordingly, the policy's restriction on abusive, personally directed, and antagonistic speech facially as applied violated the First Amendment. The Sixth Circuit then addressed the second question about whether the school board can require an in-person registration for speaking at the board meeting. The school board's public participation policy required speakers to register at least 2 days before a meeting in person during board hours from 8 a.m. to 3 p.m. If someone wants to speak at the board meeting, they would have to take time off, fill out a form in person in the Board of Education office, show his or her identification, receive a time-stamped form back, and then show up later to speak at the meeting. The court noted that this in-person pre-registration requirement can curtail a working person from easily registering. But this restriction is viewpoint neutral, so it only needs to narrowly serve a significant government interest and leave ample alternative channels. Did the in-person registration requirement serve a significant government interest? The community members argue that it did not, but the school board argued that the in-person requirement allowed the board to reserve time for those individuals who are most likely to follow through and participate in the meeting, and help to ensure that those who truly want to participate are not denied the opportunity to do so. The purpose of the in-person pre-registration requirement was to conduct its meeting in a productive and efficient manner that assures the regular agenda of the board is completed in a reasonable period of time and allows for a fair and adequate opportunity for input to be considered. The school board also provided the evidence showing that the school board had faced problems with people registering to speak then not appearing at the meeting. The court agreed that the in-person pre-registration requirement narrowly served the government interest, noting that unstructured, chaotic school board meetings not only would be inefficient, but also could deny other citizens the chance to make their voices heard. Did the school board leave the public ample alternative channels? The court reasoned those who cannot comply with the pre-registration requirement had ample alternative channels to communicate with the board through their publicly displayed email addresses or at other school functions. So the school board can require an in-person pre-registration for speaking at the board meeting. The takeaway message from this case is that school boards cannot prohibit the public speech at the board meeting merely because the board or board members are offended. It constitutes viewpoint discrimination if the board's policy places restrictions on antagonistic, abusive, and personally directed speech if those speeches are prohibited merely because it opposes or offends the board or members of the public. A final question for you. Is a school board meeting a public forum, a limited public forum, or a non-public forum? In my last video on school administrators' personal social media accounts, I mentioned that the type of forum is important in determining whether the speech can be restricted. If the speech is delivered in the public forum, such as a school district's official social media account, public streets and parks, then it cannot be restricted. What about school board meetings? A school board meeting is a limited public forum. Why? A school board meeting is not intended for a forum for public expression. You cannot attend school board meetings to talk about anything. The school board meetings are dedicated solely to the discussion of certain subjects. In a limited public forum, the government may regulate features of speech unrelated to its content through time, place, or manner restrictions. The school board has a wide leeway to do so, and those restrictions survive if they are narrowly tailored or serve a significant government interest and leave open ample alternative channels for communication of the information.